A very good afternoon to everyone, and thank you for joining our session today. Today, as the topic itself suggests, we are going to talk about the basics of investigation. Today, along with me, I have my colleagues Sahil, Kanuga and Bhavana Sunder from Nishith Desai Associates. I also have Michelle Kluyver from Addleshaw Goddard and Amit Jaju from FCI Consulting. Before we get into the panel and start discussing the nuances of investigation, I'll start briefly with giving a background. Today, in the wake of sustained government intervention, or I would say interest in corporate fraud, as well as regulatory violations, as well as the expanded scope of corporate and individual liability, we are seeing the demand of auditors as well as internal investigations increasing at length. Having said that, we have understood and seen that of late there has been a rise in economic offenses with the rise and development of technology. Along with that, we understand that companies are also looking at complying with corporate governance practices, but there are certain offenses and disruptions which cannot be avoided. We have seen a rise in internal investigations all over the world over the last few years. We have seen multinational companies and banks face various whistleblower complaints. With the increase in complaints, we also see increased awareness among the companies as to what actually constitutes fraud and corruption. This brings me to my first question to my panelists. Sahil, having worked on several cross-border investigations, the first requirement for all companies is to understand the legal landscape or the regime in which they are working. Could you please shed some light on how companies have evolved their views when it comes to fraud and corruption in the last few years? Over to you, Sahil.
Sahil, you have to unmute.
My apologies. Thank you, Payel. I think the starting point is that corporate India, or at least most of it, has accepted that fraud and corruption is just not acceptable. What was once considered as the only way to do business in a place like India is now considered as a strict no-no. The way I see it, the moral compass has shifted. And this is the message that's coming in right from the top. You have the government talking about a strict no-bribery policy. You're hearing about amendments to a bunch of laws, including the Prevention of Corruption Act itself. The bribe giver is now also responsible, and that's a big change. You have an updated Companies Auditors Report Order 2016, and now in 2020 as well, which imposes additional burdens on a statutory auditor. All of this is geared towards greater reporting and transparency. Good corporate governance is the mantra. Add to that, the board of directors that you see in 2020 is not the same board that one saw in even 5 years ago. The awareness of one's roles, responsibilities, duties, and even powers has evolved. Awareness has come, albeit at a price. I think that's where we are today.
Thank you, Sahil. But that brings me to my next question. Does that mean that every company which exists in India, every multinational which has a subsidiary, does need to have a policy in place?
Well, not just yet. SEBI laws require that every listed company should have a whistleblower policy, and employees need to be made aware of the policy. It needs to be up on the website. Under the Companies Act and rules of the Companies Act, some companies, which are essentially a listed company, companies which accept public deposits, or companies that have borrowed money from banks or financial institutions in excess of 50 crores, should establish something called a visual mechanism to report genuine concerns. The Companies Act actually provides that the mechanism should be provided with adequate safeguards against victimization of persons who use the mechanism. There is also an additional requirement of publishing the details of the mechanism on the company's website and the report of the board of directors. Now, it's important to keep in mind there's no specific law on whistleblowing applicable to private employers in India. But what we see is that some progressive companies, especially subsidiaries of multinational corporations, have already incorporated a whistleblower policy, which is a part of their extended global policy. And that includes individual employees or group of employees, in some cases even third parties. The purpose of any whistleblower policy is to encourage employees, or any other person for that matter, to report matters without the risk of subsequent victimization, discrimination, or disadvantage of any kind whatsoever. In this, it would not be out of place to talk about the recent CARO 2020 issued by the Ministry of Corporate Affairs, which was issued in line with the objective of strengthening the corporate governance framework under the Companies Act. Now, because of the recent implications of COVID on India, I think the operation of CARO has been delayed by a year, but I need to check that out. But the short point is it applies to every company, including a foreign company, as defined under the Companies Act. It requires enhanced due diligence and disclosures on the part of auditors of the eligible companies, and it's been designed to bring in greater transparency in the financial state of affairs of such companies. The revisions have put a greater onus on companies to share information with the auditors, especially on whistleblower complaints received during the course of the year. And the auditor has to consider how the company dealt with such a complaint. And if any resolution was arrived at, if any remediation was arrived at, even whether there was a separation with senior employees of the company. Essentially, the auditor has to keep in mind what's going on. There's greater transparency coming in.
Thank you, Sahil. What I understand is we do have some sort of a legal regime. There are several laws which are there in existence. How the laws actually interplay among each other is to be seen. And I think interestingly, you spoke about a lot of concepts like victimization. How do you ensure the employees are taken care of? Before we move on to that aspect, I think I have a quick question for Bhavana over here. Bhavana, could you give me an example as to what could be the circumstances where a company would seek assistance for an internal investigation? Is it every scenario, or would it be some special kind of circumstances where they would want to contact an external counsel?
Thank you, Payel. So generally, a company would seek external assistance when there is a complaint of some sort. So this could be a complaint made by the employee of the organization or a member of any related organizations. It could be an external complaint that the company has received, say from a stakeholder. It could be a complaint through the whistleblower portal that the company has opened up. And for this, it may come from within the organization or outside the organization. It could be something that's discovered in the process of disclosure in the course of audit. It could also be something that the company has become aware of and wants to look into it, and they take, suo motu cognizance into such issues that they may perceive. So the complaints could come from different parts, and depending on its seriousness, the company should certainly seek external assistance and try to conduct an internal investigation. And while doing all of this, it's very important for companies to note that they have to satisfy the legal and regulatory requirements in the jurisdiction that they are placed. So it's also important that it must be done in people should take it up proactively and do it in a fast manner, because it's possible that regulators can question investigations even years after the investigation has been completed or the complaint has been received, and say that it was dissatisfactory, for instance. So companies should ensure that they're following the regulatory requirements and satisfactorily conduct internal investigations with the assistance of external counsel.
Thanks, Bhavana. I have a follow-up question, actually. You have told us various instances where the company needs to conduct an investigation. But as in-house counsel, when I get a complaint, what are the first preliminary steps which I would need to take initially before even approaching an external counsel? It will be great if you could throw some light on that.
Sure, not a problem. So I think as an in-house counsel or an organization head, if you do receive a complaint, first get a preliminary factual understanding of what the complaint entails. And once you've grasped the facts, try to understand if there is any law or any internal company policy that this touches upon. Is there any violation? And then see to what extent there is a violation, if any. And then check the laws and the policies to see that if a formal complaint has actually been filed and if it's meeting those requirements. And then at this point, again, you should always keep in mind the regulatory requirements. If there is any disclosure that you're supposed to make in your jurisdiction, you should always keep that in mind. So once that you are aware that there is a complaint that you have on your hands, then it would be best to seek external assistance on how to conduct an internal investigation. So by external assistance, I don't mean just lawyers, but you would also require the in-house counsel team, of course, a team of lawyers, external lawyers, and you'll also require, if necessary, of course, depending on the nature of the complaint, forensic or accounting firms to assist with investigations. Again, I repeat that a timely investigation is very important to nip any larger issues in the bud and to basically also satisfy good housekeeping practices to maintain good corporate governance.
Thanks, Bhavana. That was very useful. I think we have understood how it operates in India. We have sort of a legal regime. We have discussed about the steps the company needs to take and the kind of issues that may come up before the company. We need to go a little broader and broaden our horizons. And considering we have the privilege today of having Michelle with us on the panel, who is a partner with Addleshaw Goddard and has a deep experience when it comes to complex cross-border financial crimes, investigations, including bribery and corruption, I am going to take this opportunity and ask her a few questions which would be of great interest to the entire audience. Thank you, Michelle, for joining us firstly. Michelle, do you see any changes when it comes to the kind of steps that the company needs to take when it comes to other jurisdictions? Or do you think there are certain best practices which need to be followed by the companies, for example, maybe UK or in other jurisdictions?
Thanks very much, Payel. Hi, Payel. Thanks very much. I slightly missed what you were saying in the last minute, but I'll pick up your question of whether we see similar practices in the UK and also cross-border jurisdictions. So we very much have the same sort of triggers as Bhavana was describing. And it's very important for companies to have escalation procedures that ensure that the concerns land, if you like, at the right level of the organization. I'd say the other sort of area that's really developed in the last few years is directors of companies are increasingly aware of the duties on them to make sure that they identify risks in the company and take steps to mitigate those risks. And I think that has also increased the number of internal investigations generally and the involvement of external counsel in those investigations. And again, I wanted to pick up on a point that Bhavana made, which is the increasing importance of making sure that the governance around the investigation is correct. Because the way in which the investigation has been approached is something that can be challenged either by the individuals who have been affected by the investigations or can be scrutinized at a later point by other regulators and enforcement agencies. I think the process for in-house counsel that you described is very similar. Perhaps the one area that's slightly different is those initial steps that are taken to try and work out what the issues are. Sometimes I would say that in-house counsel involve external lawyers even at that stage. And the concern there, of course, is to try and make sure that there is privilege in the investigation as soon as possible, and that the right governance, again, is being followed even in those very, very early initial conversations, because people can say a lot of important things at the outset of an organization. But otherwise, I do think there is an emerging best practice internationally that we increasingly see, the best practice from all jurisdictions across the world being assembled into a package, if you like.
Thank you, Michelle. Michelle, I mean, before you threw some concepts in relation to privilege, which are of great significance. But before I move into that, if you could briefly tell us what are the actual steps that are involved in an investigation process, which I am guessing would be more or less similar across all jurisdictions, and considering the fact that nowadays we are involved in investigations which have always a cross-border element involved in it.
Thanks, Payel. So I think the first step, obviously, is you have to get as much of an understanding as is possible as to what the issue is, what the concerns are, enough of the background so you can start to think about who the people are who are likely to be involved, the functions that are likely to be involved, etc. But once you've grappled with those sorts of formalities, I think the first two words that always spring to mind are document preservation. This is absolutely critical, and it's critical that in-house counsel turn their minds to it at the very outset of the investigation. In particular, if there is any chance that an external authority may become involved, they will be very concerned to understand that the company has taken all reasonable steps to ensure evidence cannot be destroyed. And allied to that, I think you also need to turn your mind to protecting the assets of the company. So, for example, if there is any concern about directors who have, let's say, signing authorities, make sure those signing authorities are removed. If there are any concerns about people accessing the premises, make sure their security is removed. So preserving assets, protecting assets, and ensuring document preservation is an absolute critical step. Now, the document process itself, I think, as all of us know, and I'm sure all those joining know, it can be quite complicated. It depends on the IT systems and document storage systems that a company has. But, hopefully with any luck, you'll be able to do a lot of that centrally, working with the IT team. And then there'll be a separate issue about whether employees have relevant documents on portable devices like laptops and mobile phones, which tend to be absolutely critical in fraud and corruption investigations. You'll decide on who the investigation team is very early on. And there are normally a range of stakeholders within the business who need to get involved. So obviously in-house counsel, the compliance team, the IT team will be critical. Sometimes, depending on the business and the issues, the HR team, the communications team, and then the relevant member of the board and the relevant person in the business line. That's sort of what your typical investigation team would look like. You then put some very strong protocols around that to make sure you maintain confidentiality in the investigation as much as possible. It's always a challenge, and obviously the bigger the team is, the bigger the challenge, but that's something you have to turn your mind to. And then it's obviously important for the team to work out the scope of the investigation, the lines of communication externally and internally. There'll then be a massive exercise involving the forensic team in collecting the data, the relevant data, in a forensically sound way, in a way, particularly if you think a US or UK or Indian law enforcement authority might become involved, where you can satisfy them that the data has been preserved to the standard required if this is a matter that ends up going to court. So that's a very important step. There'll then be usually a massive task in reviewing that material, interviewing witnesses, making sure you have the full universe of facts, and then guiding the client on what their obligations are and what they should be doing along that process. And obviously, if you're in a jurisdiction like the US, where self-reporting is very common, you will need to involve US counsel to work out at which stage of the investigation you might be going to the DOJ, for example. And then you also need to give consideration to the self-reporting requirements of all other jurisdictions involved. Self-reporting, for example, is also a very big issue in the UK. It'd be interesting to hear later, what the approach is in India. But that I would say, every investigation's different, but that I would say is the core structure for most investigations.
Thank you, Michelle. So I think the takeaway for me is it's a little fact specific. Every investigation needs to chart out its own scope and work plan, and it cannot be a one-size-fits-all approach that can be taken. Moving on to the topic which you slightly touched upon earlier, privilege. I think it's talked all over across jurisdictions. It differs differently across jurisdictions, whereas we have seen a lot of rulings coming in from the courts in UK, especially dealing with legal advice privilege, litigation privilege, and trying to draw a line as to where what begins. In India, frankly, it has been a gray area. And when it comes to looking up at privilege, we go back and rely on the UK ruling. In this context, I wanted to understand how important do you think the concept of privilege is in investigations? And will it make a difference when we are at the outset itself drafting our engagement letters? When you say which law governs the investigation, or the fact that this is legal advice pursuant to providing for a potential litigation, will the language, the law make a difference when you're determining which law will govern privilege in an investigation?
Thanks, Payel. I think you've absolutely nailed it. The law of privilege in investigations is definitely a grey area at the moment. I think it's highly unsatisfactory because, to my mind, where a company employs external counsel to provide legal advice on corporate risks, corporate duties, corporate obligations, and the investigation is carried out for that purpose so that the lawyers can give that advice based on a proper understanding of the facts. My own view is that should be protected by privilege in the same way a piece of litigation would be. But at the moment, that is not where the courts are. And that does mean a very careful analysis of privilege has to be done in all relevant jurisdictions. And from the point of view of the UK, what's really important is to try and work out, what is already contentious and likely to give rise to litigation in the investigation, because that may give you a basis for asserting litigation privilege, which is a much wider privilege in the UK than legal advice privilege. But a huge amount of attention has to be paid to this issue, and there is a particular risk around conducting witness interviews and whether they will be privileged based on the current state of the law. So that is where we are at the moment. Unfortunately, I don't think we can simply assert which countries' privilege laws we will apply in an investigation. At the moment, at least the approach that's adopted in the UK is that it is the law of the forum. So if we are conducting an investigation in the UK, it is the UK's privilege laws that apply. Otherwise, we would all simply adopt the laws of the US, which are much wider and more easily applied to investigations. It may be that conflicts of laws point develops over time, but at the moment it's quite a blunt approach, and we'll continue, I think, to have to grapple with the fine details of the cases, many of which contradict each other, unfortunately. So it's a difficult technical exercise. We always try to take privilege in an investigation if we can, because that gives the client the best possible range of choices. At the end of the day, if they wish to do so, they can, of course, waive privilege, but you need to have privilege in order to have that luxury.
Thank you, Michelle. It was really insightful. I'm sure the audience has understood, at least when they are faced with a situation, they cannot ignore the concept of privilege and move ahead with the investigation. Shifting the gears a little bit, while we have understood how the investigation process works, we understand an important component of that is the assistance and support of our forensic and technical experts. Let me welcome our next panelist, Mr. Amit Jaju, who's a Senior Managing Director in FTI Consulting and also heads the firm's Technology and Financial Crime Practice. Welcome, Amit, to the session. Having worked with Amit on several occasions and knowing his expertise, I cannot stop myself by asking him that, having dealt with so many investigations which involve heavy data collection, employee data, which is scattered, which is always available through various sources, how would you go about this entire process? And if you could explain us the steps on collection of the data, processing of the data, and more importantly, if the data is located in different jurisdictions, what is the step and the process you would follow?
So thanks, Payel. Good evening, everyone. Am I audible?
Yeah, Amit, we can hear you.
Great, perfect. See, as my fellow panelists have touched upon, that investigations range from complexities, and size, a number of custodians involved. So data is generally a very important component to it. In terms of the steps that should be followed, there are certain standard steps we follow, which takes care of a lot of these, concerns that you have mentioned. So the first one is to understand the case. So what this case is all about. So before jumping into trying to collect what data is in front of us, we would like to understand what is this case all about. Is it data theft? Is it intellectual property theft? Is it bribery and corruption? Is it a financial fraud case? Depending on that, we would try and create a landscape of what data would be important for that case. So whether it is data from laptops, which would be primarily documents and emails, it could be emails on the server, because somebody can delete emails on the laptop, so you would need the real copies from the server which are untouched. It could be instant messages. If you're talking about trader surveillance and front running and trader related frauds, you would need Bloomberg chats and things like that. So depending on the type of case, you would create a landscape of what data is relevant from a company perspective and where is it stored. Then you would also focus on the time frame of the investigation. Is it current? Are we doing a backdated investigation of a certain time frame, a few years from now, or are we looking at different time frames split between different calendar months and years? So depending on that, you would see which systems were live then, where are the backups. So all of that kind of gives answers to what are we looking at. Then we would definitely work with counsel and ensure that we kind of communicate legal hold and implement that from a technology perspective. Now, it could be tricky because we would generally work with two stakeholders, the IT teams of our clients who will implement the legal hold to make sure that data is not deleted and it's preserved, but also how does that get communicated to the custodians? So that could be the time when the process is broken to them that this is going to happen, and we need your help and cooperation in conducting the data collection, primarily from the mobile devices such as laptops. We would also look at mobile devices such as tablets and mobile phones, because they are very relevant. We all know that a lot of business discussions happen on apps such as WhatsApp, and of course it opens up a new Pandora's box on discussions around data privacy, what's personal, what's official. But anywhere where there is a company provided asset or a company managed device, that becomes an important component of data source. We also look at other sources such as cloud storage. So nowadays, a lot of companies are using cloud-based emails and storage such as OneDrive, Google Drive. So we look at that. We look at DLP devices, which are data leakage prevention systems companies have, which also give an indication of has somebody copied a lot of data, maybe a few months before they resigned, or during the course of the investigation, which was told to them. They started moving data, deleting data. So a DLP system can track a lot of these logs which are relevant. We also look at transaction systems, so things like SAP, Oracle, core banking systems, which will have a lot of details around transactions, which will not be on emails and documents. So what transactions were initiated, approved by certain individuals, which are relevant to the transaction or to the parties involved in the transaction. So that's there. So that's the step around locating the data. And then we start collecting data. And as Michelle touched upon, it has to be in a forensically sound manner. Because if the procedures are not followed properly, then the regulators or the courts might raise questions on the integrity of the data itself. So everything has to be done in a forensically sound manner. The tools that needs to be used, the procedures, the documentation has to be completely perfect. How the data is handled, how it is stored, and now, of course, with data privacy, we have to ensure that data is securely handled. So the kind of encryption that's used, the devices on which it is stored, so all of that goes a long way in protecting the overall case as well. Then we look at processing. Now, processing is a very important component here, because once you have data, as you can see, it's from different sources. Now, generally on all investigations, timing is something which is not available. So we don't have enough time to do things the way we would want to do in a best case scenario. So making sure that processing is efficient, but also the varied sources from where we got the data can be collaborated together and can be presented in an easily understandable manner, and it is filtered in a correct manner, where millions of records can be then reduced into the number of hundreds or thousands of records that needs to be reviewed and analyzed, and that has to be done quickly. So processing is an important component. We have also seen cases where there have been a lot of duplications in the way. So clients have shared data from different sources. There's a lot of duplication. So dedupe becomes an important component there. Trying to do analytics on that data to see who's talking to whom. How can you reduce the population, and then help the council review that in a more visually engaging manner, rather than doing it in a linear fashion, how we review our own emails, how tedious it becomes to just look through emails on Outlook. So making it more visually interactive and more efficient. That's the processing side. And of course, the followed by the review process, where the data is loaded on a forensically sound and in a legal review platform or an e-discovery platform, which I would say that has becoming a norm in India in past couple of years. As the complexity and the criticality of cases have increased, and a lot of cases in India we have worked on have the global angle to them. So more and more, I think 90% of our cases use the same process that we would use on an international matter in India as well. So that's the end-to-end process at a broad level.
Thanks, Amit. I realize that an investigation to be successful and to reach its ultimate goal is just not possible without the forensic element involved in it and without the right appropriate usage of technology. But this also raises certain questions, Amit. How do you balance or have a fine balance maintained when it comes to the data privacy issues? Earlier, it was just GDPR. Now we have so many data privacy rules and laws even laid down in India as well. How do you balance between the data privacy concerns of the employees as well as the statutory requirements, and which could involve even laws across jurisdictions? How, I would I mean, my question is, the employees in some cases have company devices, whereas some cases we have a policy of a bring your own device policy. The SIM card might be the company and the phone might be of the employee. So there are several nuances and different kind of permutation combinations which are applicable. How would you go about balancing both sides?
Correct. Thanks, Pal, for asking that question. And I think the first step to this area is to first recognizing that there is a component of data privacy that needs to be addressed. I think which never used to be the case earlier, but now, as you said, there are so many statutes and requirements. So thinking about data privacy initially itself, goes a long way. Generally my process is that we divide investigation into three aspects from a data privacy perspective. The individual, who are individual or individuals involved, directly or indirectly, the company itself or the client, and the data. So you have to look at all these three entities in silo and look at what data privacy statute or requirements would be relevant. I also consult my IG or information governance colleagues all around the world on a regular basis, because if you're talking about United States, there is no single data privacy law there. So California has its own law. There's a certain law in different states. Then at the country level, you have to look at different data privacy laws when it comes to financial data, and same in India, for instance, right? So I consult with the relevant individuals to see what's important. When it comes to individuals, we look at their citizenship, their domicile status. So if you are looking at a European national, then you have to be very careful to make sure that GDPR rules are applied for anything to do with that individual who's covered in that investigation. When you look at companies, third parties involved in the investigation, you look at where they are registered, under which data privacy law are they covered. Then we apply those relevant steps there. And then the data itself. So if you're looking at emails and documents of an Indian custodian, then you're looking at the India-specific steps. If you're looking at transaction data, which also has a lot of data of American nationals based in California, for instance. I was working on an insurance fraud case, which involved a lot of American nationals based in California, and their details was in the data. So we have to be very careful on how we deal with that information. So splitting that into the individuals and the company/entities and the data itself, and then looking at various procedures. And of course, from an investigation standpoint, we have detailed procedures on what we need to do, how we handle the data, how we store it, how do we mask the data. So we have set algorithms in which the algorithm identifies personal information, whether it is name, email address, phone numbers, anything where you could locate the individual, and then mask that information and create aliases automatically. So that's very important from an IG perspective. And when it comes to mobile devices, it's extremely complicated, and there is no single answer to it. So companies provide mobile devices in some cases to executives. In some cases, you bring your own device, but you install companies' applications on your phone. In most cases, we install something called an MDM, or mobile device management application, which creates a secure layer within your own personal phone where your company's app sits. So at times we can't notice it these days, but there's a layer that always sits behind in your phone that covers and governs all the company-related applications. So most important thing is here, what's the policy at the company side, right? What does the IT policy say? What does the employment contract say? So for instance, employment contract could clearly say that if you use company resources, whether in your personal phone or phone provided by the company, as part of an investigation, we may need to access your information, but ensuring the privacy of your data, our procedures would ensure that. But you would cooperate, in such investigation and provide as much data as possible. But if there is no such, and of course, I'll leave it to maybe Sahil and Michelle to confirm that. But if there is no such provision in the employment contract, then maybe it comes to a different conversation with the employee. If he want to give his consent to provide that data. But the procedure itself, from a technology standpoint, is very robust. What we follow, we demonstrate to the custodian that there is no manual witch hunting of his data on the phone. There are specified keywords and patterns or search terms which we are looking for, which are relevant for this case. And if required, we can do the entire process in front of the custodian, where the phone is or the laptop is forensically collected, the data is mounted on a processing platform, the search terms are run, results are being pulled out, and we can return the device and remove the host data, or secure it and keep it with 2 passwords, 1 password with us and 1 password with the custodian, so that there is a copy of data preserved. But unless we find something relevant and we need to go back to the raw image, only then we open that. So that kind of removes the fear of witch hunting on his personal phone, which could also include bank information and personal messages and things like that. So there are procedures available to deal with that. So you have to look at both technical and contractual aspects of that.
Thank you, Amit. I think it's not just don't wait for a complaint to come or when you start investigating. The process starts way earlier when you draft your policies itself. It needs to be robust, it needs to be tight, and think about all kind of contemplate situations which could come in future and accordingly build in those relevant clauses itself. Amit, I have another question for you in relation to this, but we'll come back to you. Let me go back to Sahil. Sahil, we see a lot of whistleblower complaints coming in these days. In most cases, we see whistleblowers trying to be anonymous. What do you think the company can do to ensure the protection of employees who are raising this complaint? We do not want them to be victimized. Please let us know your thoughts on this.
Thank you. So I think companies definitely need to have a robust mechanism in place for investigating and resolving whistleblower complaints. In this regard, companies must ensure adequate protection to whistleblowers. This is done in the form of non-retaliation or non-victimization policies. As part of this, the company also needs to guarantee anonymity or confidentiality, whatever the whistleblower seeks. So if tomorrow the whistleblower doesn't want to reveal his or her identity, you need to respect that. But the larger point over here is policies are only part of the solution. There is also a need to create a compliance culture and focus on importance of reporting and strengthening adherence to such policies. When the employees realize that there are policies and the policies are being given meaning and they are being acted upon, you will create an environment where people will be willing to come forward and give their grievances. It changes the culture of the organization.
Thank you, Sahil. Considering how we approach a complaint itself and how we ensure protection, Bhavana, in your view and experience, having dealt with several investigations, there could be probable scenarios where you're facing complaints where you need to test the merit of it as well. How do you think the company should deal or handle frivolous anonymous complaints?
Thanks, Payel. Can you hear me? Hello? The company may face
Yes, Bhavana, we can hear you.
frivolous or malicious anonymous complaints. It's always difficult to have an anonymous whistleblower policy and to avoid these frivolous malicious complaints, because there could be several motives for it, to harm the company itself or to harm certain particular individuals or executives. So I think, in my opinion, one thing that could be done is, in the company policy, there could be a requirement to have specific complaints instead of generic complaints. So the more detail you put into the complaint, the more, obviously not in all situations, but there is also a larger degree of veracity to it, maybe. So, you could expect more specific complaints over just generic statements, such as more specific, detailed, factual complaints. And also, I think generally a company should have a policy of training its employees of the company policy and whistleblower policy. So in that case, employees themselves would understand the threshold at which they can make a complaint report. And hopefully, with such trainings and certain maturity of the company's internal policies, the employees themselves will imbibe a culture of responsible complaining, responsible reporting, or whistleblowing.
Thanks, Bhavana. I'll do a quick recap. We have understood the existing legal regime. We have understood the kind of complaints that have come in. We have dealt with how companies should approach such complaints, do it internally or approach external counsel, the relevance of the technology and the forensic aspect to it, the issues which could come up during the investigation process, how you conduct it, and also how you ensure that nobody's life is put at risk, but at the same time, you can filter the complaints which have no merit. Which brings me to my question. Once you have concluded the investigation, what next? Michelle, I would ask you at this stage, having done so many investigations, what would be the steps you would recommend from a remediation perspective? Would you recommend disclosure or is it fact specific? Because disclosure requirements are also different across jurisdictions. It could entail some kind of implications in one country and a different for India perspective maybe, because the company has various affiliates in other jurisdictions. What kind of a consolidated view would be taken in that scenario?
Thanks, Payel. So remediation is a critical step because from the corporate's perspective, the internal investigation is about identifying the risk, identifying the harm, working out why it came about, and then making sure that you fix that. And that will often be down to either identifying a gap in your policies or internal controls or working out how somebody has circumvented them. And remediation, I think, therefore, doesn't just happen at the end of the investigation. It is something you're thinking about right at the outset and constantly keeping out of under review. So if there is some control that you identify that has been circumvented, for example, even in the course of the investigation, you'll be asking yourself, how can I strengthen that control? How can the client strengthen that control to make sure this doesn't happen again? Depending on what the investigation surfaces, some clients will conduct a comprehensive review exercise on some aspect of their internal structures. For other clients, it might just be tweaking things here and there. But where they'll want to get to by the end of the process is they've dealt with the issues that have come up in the investigation, and they have taken sufficient proportionate steps internally to try and prevent the issue from arising again. On the question of disclosure, it's, you know, highly fact specific, highly jurisdiction specific. Sometimes where you have listed companies, for example, they might be under a company's law obligation to announce an investigation to the market, where companies don't have those sorts of obligations. They may choose to, they may choose not to. It's a very kind of nuanced process, and you know, the board will usually get involved in that. They will turn their minds to issues like the company's reputation, not just what it has to do, but what it wants to be seen to be doing. Sometimes it may result in a report to another enforcement authority. There isn't really a sort of one-size-fits-all approach, but those are the types of issues that the board will turn its mind to.
Thanks, Michelle. I already see a list of questions which have piled up. But before I take on the questions, one last question for Sahil actually. Sahil, as an Indian counsel, once an investigation has been concluded, how should companies handle the outcome, particularly if it involves the termination or suspension of employees at senior level?
So I'll be very quick. Thank you for the question. I'm conscious of the fact that there are many questions and a lot of this will be resolved in Q&A. So to answer your question very, very quickly, The reporting requirements of regulators such as SEBI should be strictly followed by all listed companies. You have to be very, very careful on that. In addition to that, the sectoral regulator may be required to be reported to, depending on which sector the company is in action. The next component becomes the statutory auditor as well as the board, who need to be fully aware and satisfied. We've had investigations in the past where it was done at the behest of the shareholder. So that's just the way these things start up, because the investigation, you have a whistleblower that comes up at a different level, and the shareholder initiates the investigation. But the Indian board needs to be fully aware of it, as well as the Indian statutory auditor, and they both need to be satisfied. When there is an outcome of terminating or suspending employees at senior levels, the company needs to handle these things sensitively, because it becomes a reputational issue also. At this stage, you should consider taking the advice of an employment lawyer and comply with all the policies in this regard. What needs to come out is adequate and proportionate remediation. As long as you've gotten to the bottom of the facts, you've identified the issue, and you've adequately and proportionately remediated it such that you've completely eliminated or significantly reduced the chance of the same issue arising again, it should satisfy most people.
Thanks, Kyle. Since we are losing out on our time, I'm going to just quickly move into the Q&A session. And the question is for you as well as for Michelle. Especially in the given circumstances with COVID-19, do you think it will lead to greater instances of employee fraud? For example, the fact that people are working from home and have some control over finances. How do you see this situation panning out? Michelle and Sahil, your thoughts on this?
Michelle, I'll let you go first.
Thanks, Payel. Thanks, Sahil. I think it's a very good question, and all companies should be turning their attention to their financial controls and what additional steps they need to ensure are taken because of the fact that so many people are working remotely. And I know that so many firms and companies have already done that. So I think that is a risk. I've seen different ways in which it's been managed. For example, financial controllers sending out messages to say, do not act on any apparent instruction from me without checking with me on the phone, really some basic things just to make people pause and ask themselves all the time, is this genuine? Is this genuine? And the financial function taking control. I think, I think the risk of employee fraud is there, but I think there's an even greater risk of external fraud, people taking advantage of the fact that people are online, taking advantage of their psychology. The authorities put out a lot of warnings on this. For regulated firms such as banks, it relates to requirements such as operational resilience. So I think the business continuity teams, the senior management teams are indeed paying a lot of attention to how they mitigate fraud risk generally as a result of COVID-19.
So I think Michelle's covered everything. She's hit the nail on the head as far as that one is concerned. I definitely see an increase in risk coming out of COVID-19 because your traditional checks and balances that exist in an office environment are not there when you're sitting at home. This is until and unless the company has managed to inculcate policies which are digital and are online. So even if you're sitting at home on your laptop, you still have to go through the same level of hoops. But this doesn't take away the risk of external fraud. So the element of fraud is a much higher risk in the time of COVID-19, whether internal or external for that matter.
Thanks, Michelle. Thanks, Sahil. Moving on to the next question, I think, Michelle, this is for you. This is coming from the aspect of when we talk about privilege as well as about engagement of the council and which law prevails. What would you feel if investigators are engaged by the qualified lawyer, or how should the engagement actually pan out, whether it should be done by an in-house general counsel? Who should basically be engaging this investigators?
Thanks, Payel. So, I mean, it's quite usual for in-house GC to engage external counsel as investigators. That's absolutely fine. It's not a requirement, because at least from a UK perspective, if there is an engagement between the client and external counsel, then the sort of legal advice will be privileged. The really important discipline from a UK perspective is to make sure we know who the client group is, who's within the client group on the client side, because that's very important to determining who has the advantage of the legal privilege. In the UK, in-house counsel are considered equal to external counsel in terms of being able to provide the business with independent legal advice that attracts privilege. That's different in some jurisdictions. I think it may be different in India. It's different in parts of Europe, where sometimes the in-house counsel isn't seen as being sufficiently independent. But in the UK, that's not an issue. And if, for example, sometimes clients approach us and ask whether the investigation can be conducted by their in-house legal team, we would say yes, and we'd give them the guidance around that and how the in-house GC should structure things in order to maximize privilege. But in the UK, we've got the advantage that it's very clear that in-house counsel do have the same standing as external counsel, with one exception where it comes to European competition investigations. That's a very technical point, but by and large, the in-house GC can take on the lead role.
Thanks, Michelle. I think this is going to be the... Sorry, Sahil, go ahead.
Yeah, sorry, I just had a little bit on that from an Indian law perspective. So privilege is something that is extended to exchange between a client and an advocate, vakil, barrister, that sort of thing. Interestingly, a general counsel of a company, when he takes up employment within the realm of a company, is expected to give up his sanad, or his ability to practice law. Therefore, in the eyes of a law, he is no longer an advocate. So theoretically, if a general counsel were to appoint a forensic service provider directly and conduct his own investigation, I'm not very sure whether privilege would extend to that. I know for a fact that that's not been tested in a court just yet. So I would not want to run that risk. But general counsel appoints his lawyer, and the lawyer goes down the road of appointing the entire team. That's absolutely fine from an Indian law perspective. Again, all of this is going to be tested and evolved as time goes by. But if you are going to be starting off an investigation, best to structure it right.
Thanks, Sahil. I'm conscious of the time. It's already 4, but if the host allows me, I will just have one last question for Amit over here, and then we can wrap up with the panel. Amit, coming back to the fact where we spoke about data privacy, the processes, how you need to maintain a fine balance, when you have such a large universe presented before you, how would you differentiate between the data which is actually pertinent to the complaint itself and what includes employees' personal data? If you could shed some light on that.
Sure. Thanks, Payel. So I think evolving area when it comes to data segregation between the official data related to the complaint, and then what is personal. Now, the question generally gets solved when we look at the source itself. So as I said, when we are trying to scope the investigation and look at the landscape of IT systems and data sources, we create data classification map around what is what. So email platform from the client is definitely official data source. And then once we capture all emails, as I said, we run search terms to identify emails that are relevant for the investigation. When it comes to devices such as mobile phones, there would be, as I said, various containers within the phone that house the company's applications, which would predominantly be official data. And then in that data, again, we run search terms and different technologies and analytics to identify data relevant to the investigation. When it comes to things like WhatsApp, text messages, and especially when the phone is not provided by the company, that's when, as I said, we have to work through the different contracts and policies of the company, and then work with the custodian to create a workflow where the custodian is comfortable, and at the same time, we are able to achieve what we specifically need to achieve on that data. So we're creating a robust workflow. For instance, we have a specific tool and a workflow on trying to filter WhatsApp messages. So for the time we forensically acquire a phone, we put the database on this tool, and the custodian can see the full process. So the backup gets opened up. We run search terms on all the WhatsApp messages, only messages relevant to the case and where the phone numbers are of one of the employees of the company or any other relevant external person who might be there. Only those messages are filtered out and taken out for the investigation. So the custodian can see that. And again, this is a call which we take along in consultation with the counsel and the client. But there are various methods, and it's difficult to say there is one size fit all solution here. Sources are different. Just having that awareness and these discussions with the client and the counsel around the different challenges and sources goes a long way in trying to plan this. But it's doable. It's not difficult. In today's world, we have the kind of tools and technologies available at our hands and in the hand of investigators. It has become much easier.
Thanks, Amit. This is indeed useful to know, because you never know when you're faced with a situation when you are getting investigated. It's easier to say when you are as a part of the investigation team and investigating somebody else. It's good to know that we can segregate the data itself. There are some few more questions. There are some few more questions, but considering we have run out of time already, we will take them up separately and we will get back to the participants on those queries on email. Thank you, everybody, all my esteemed panelists for joining the session today and educating all of us about the pros and cons involved in investigation. Over to you, Diane.
Thank you, Payel, for a very interesting discussion this evening. I'd like to thank all our panelists, Sahil, Payel, Bhavana, Michelle Kluyver, Amit, Jaju, for a very insightful and educative discussion this evening. Our next session will be held on rethinking fund terms and LP-GP dynamics at 1800 hours IST later this evening. Stay tuned for interesting sessions every day. You can register on our website or through LinkedIn. Thank you for joining us today. You may now disconnect your lines.